realistically, the thing that you're going to see the most and that most people need to recognize is that we are walking around with records. At all times, we are walking around with what is effectively a transcript or court record of our communications with the other parent. So, sending nasty texts and things of that nature is something that is going to come back and bite you in the ass
every single time.
My name's Ed Emmerich. I am a marital and family law attorney in Central Florida. I've been practicing family law for approximately 11 years at this time. We wanted to start this page or start these videos or this video series. I'm not really sure what it's even going to be yet, in order to raise awareness for folks about some of the intricacies of family law. We want to talk about some things that I think would be helpful for everyone if they had enough knowledge about to talk to their legislators. We're going to cover some of that. And in addition to that, seemed like everybody was doing it. So we wanted to give it a shot ourselves and see what would come of it and start a dialogue with the people that we represent and with the people we know in our community.
So you touched on time sharing. So tell me some myths about 50-50 time sharing in the state of Florida specifically.
Myths about 50-50 time sharing. Right now, one of the things we're seeing is that people kind of assume that because there is a presumption in favor of equal time sharing, that they are just going to get that. And while that is the most likely outcome in most cases, it is not automatic. There are circumstances where you will not get that. And as I just mentioned, with respect to things being more expensive, things not being as easy as they seem, just because there's a presumption in favor of equal time sharing does not mean that the other parent is not going to try to get more than equal time sharing. It also does not mean that it is not within consideration of your circumstances. For instance, if I have a job where I work 5 nights a week from 6 p.m. to 6 a.m., and I cannot change that during the course of my custody litigation, then there is a fair chance that I am going to have difficulty getting 50-50 time sharing because I'm not available for 50-50 time sharing. If, for instance, I am a convicted sex offender, I'm probably not still going to get 50-50 time sharing. If I have domestic violence in my relationship, I may still get 50-50 time sharing at the end, but there's going to be a little bit of a process for that in most circumstances. If there's evidence of a substance abuse issue, there's a possibility that I'm going to have to jump through some hoops before I wind up with my equal time sharing. In addition to that, in paternity cases, there's a lot more to this. We've seen some recent statutory changes. Paternity cases are cases where there's an unwed couple that have a child together. Now, this may be a circumstance where you have same sex. It may be, different sexes, and they have, custody of a child through one variation or another, one way or the other, where there is not a parenting plan, even if you're married, where there is not a parenting plan, there is not necessarily going to be some immediate right to equal time sharing. And in fact, there is some legal question associated with what the circumstances are for your child or children when you're in a paternity circumstance. We're seeing some indication from some courts that fathers immediately have a right to equal time sharing. We're seeing indications from other courts that these statutory changes did not create an actual right to time sharing. It created a right to that child in some level or another, but until or unless you have some variation of parenting plan saying whose day is whose, you are in a similar circumstance to a married couple that have children. Whoever has the child has superior rights to the other person to that child, in that the other parent can't necessarily take the child away from that parent without some variation of court order. Now, it is true that in paternity cases, nowadays, the father has superior rights to everyone other than the mother or the other parent in that circumstance. But it is not such that they could take the child away from mom. So if you have a child that is younger than school age, oftentimes the parent that has the child is going to be able to prevent the other parent from getting time with that child until such time as you file some variation of court action and get a court order establishing a time sharing schedule. And so one of the things that folks that are in that circumstance need to do is they need to get something filed with the court pretty immediately when their relationship ends to prevent that type of thing from happening.